Hello again. How may I help you?
I wanted to ask you something about third-party debt collectors. What are my rights and how do I deal with the annoying phone calls? This is for a bullshit order passed down by the courts for my parking ticket.
Well, if the debt collection company keeps phoning you, do not get into an argument about if you owe the debt or not. Simply tell the clerk to put the requests in writing and send them to the address they have on file. Then wait for the letter to arrive. This is where you can really get them. See, when a debt collector contacts you, they are not the party to which you had the contract, and in fact they purchased the debt knowing it was not collectible. This is a really stupid thing for them to do. If you didn't pay the original parking ticket, why in the world would you agree to pay a third party, to which you have no contract? What you should also know is that the company that you owed in the first place has in fact been paid for the debt by the collection company, but even better is that the original company also wrote the debt off on their tax return.
Okay, but there must be rules or something that I can use against them, right?
Yes. If you are dealing with this yourself, you have a better chance to get it resolved. There are a few laws or statutes that will help you. They are the Fair Debt and Collections Act, as well as the Fair Credit Reporting Act, and the Bills of Exchange Act. If you really want to mess with them, then also use the Bank of Canada Act. Under Section 5 and 6 of the Bank of Canada Act, you will see that the money we use today is not legal tender, nor is it a promissory note under the Bills of Exchange Act. All invoices, bills and alike are subject to the Bills of Exchange Act. Therefore, seeing as the money is worthless and you're subject to the Bills of Exchange Act, how can you lawfully pay a debt?
My guess is, you can't.
Exactly. And when they send you some crap in the mail, you now have a name to deal with. Like your other issue, you now have a party to file a lawsuit against.
Right. I was talking to a friend of mine who had to deal with this crap, and they hired a lawyer. Needless to say, it didn't go well.
No surprise there. The other thing that you may want to keep in mind is that if the alleged debt is over 2 years old, then whomever is making the claim is statute limitations barred. This law is the Statute of Limitations Act and is yet another law for you to research. The Statute of Limitations puts limits on who can claim and how long they have to claim an injury. They will allege that the debt not being paid is an injury. As we have discussed before, the banks and credit card companies are not permitted to loan any of their own assets. Do not, however, try to use the information here if you are trying to get out of a debt to which you created and signed a document for.
Right. If I signed a loan application, then I agreed to the debt, and so trying to skate out from under it would be unethical and morally wrong.
Exactly.
In this case, however, the parking infraction was because I parked on the street instead of using the driveway. I was simply dropping something off for a friend.
Why didn't you park in the driveway?
I didn't park in the driveway because it was full of other vehicles and there wasn't sufficient room for my vehicle. Despite me taking pictures and sending them in to the court prior to trial, the courts didn't care about that. When I requested a transcript of the case so I could appeal it to a higher court, it was misplaced. How convenient is that?
No problem, dear. Simply make an affidavit out and bring it to the criminal court and do what is known as laying in information. The courts will give you some paperwork to fill out and you will be on your way to criminal court.
How do I know I will get a fair hearing?
You never know if you will get a fair trial. In fact, assume you won't. However, you have the right to record your own case, if it is in Ontario court and you have a lawful excuse as the courts have lost the transcript to your other case. So now the bastards have hung themselves out dry by pulling this bullshit. Now, they cannot now use the transcript as evidence against you.
The courts have told me I can't record in court.
That is bullshit. You can record your own case but nothing else. This only applies to Ontario cases as far as I know. Things down south may also permit you to record your case. I am not sure.
How is this recorded evidence used in my criminal case?
Enter it as an exhibit along with the document that says you can record your case and watch them try to get this tossed out. The law, however, is on your side. The Recording of Evidence Act of 1962 is your weapon. It is applied lawfully like this, while Section 136(1) of the Courts of Justice Act prevents members of the public who are not parties before the court to record court proceedings, Clearly, Section 136, 2b of the Courts of Justice Act states, "Nothing shall prevent a lawyer, a party acting in person or a journalist from unobtrusively making an audio recording at a court hearing, in the manner that has been approved by the judge, for the sole purpose of supplementing or replacing handwritten notes." In an official directive to Ontario's judges by the former Chief Justice of Ontario, W.G. Howland, and approved by the Ontario Courts Advisory Council, the courts were also directed that recording under Section 136(2) of the Courts of Justice Act was to be considered as being approved without an oral or written application to the presiding judge. You can get this document at www.canadacourtwatch.com.
So since I am a party to this case, I can record my own case. So the bastards lie in order to cover up any wrongdoing that they do, and you have no way to prove otherwise.
Right. You could also locate the officer before you go into court, for any matter, who laid the charge, and see if he or she will remove the charge before court.
Looking around, I don't see the officer here.
It is close to lunchtime, so you will likely find him or her down the street at the Tim Hortons.
On one other matter, some years ago I tried to show the officer where she was breaking the law. She would not even look at the documents or speak with me about it.
And you are surprised about that?
Not anymore.
What you did in that case was inform the officer, and she could no longer state she didn't know.
So I could use this in court as well?
Yes. What was this issue for?
The officer towed my car to the impound lot for being illegally parked on the street, when the parking lot where I live was being repaved. All the cars from the parking lot were parked there.
Well, dear, according to the criminal code, they need the owner's consent to tow a vehicle, and clearly you did not want them to tow your car.
Exactly. But that was a while ago now.
It doesn't matter. If the case you're dealing with is fraud, then it doesn't have an expiration date. Could have been 10 years ago. The Statute of Limitations does not apply to fraud or murder cases. The Statute of Limitations only applies to contract law or family law for the most part. There are exceptions, so be sure of what you're doing. If you would add her name, you could file a complaint with the sergeant or the chief of police. I don't think this will do you much good, however, because the police department looks after its own and they use the courts to assist them in policing the public. You could also write a letter to the Office of the Independent Review Director. This office is, however, not independent and is run by the provincial government.
She wouldn't give me her name or badge number, and as I have already found out, the government for the province doesn't want to deal with the issues created by those who are supposed to be under their control.
If you ask an officer or public official for information to which they have knowledge and it's a matter of importance and not of a personal nature, then under Section 336 and 337 of the Criminal Code of Canada they are legally obligated to provide it to you. Also note that the tow bill, and all charges related to it, was a contract between the officer and the tow truck company. You did not consent or make the contract, and as such the officer who ordered the vehicle towed is liable. I assume you paid to have the vehicle released. You might consider charging the police department for the costs, and hit them for 3 times the value under the Deceptive Trade Practices Act. Right. I was reading an article not too long ago where the police department kicked the mayor of a town out from the meetings they had, even though he was on the board.
What do I need to do now with the fact that these turkeys have likely filed fraudulent documents under my name?
You can write a letter to each of the 3 credit reporting agencies and get a copy of your credit report. You are permitted to get 1 copy of your credit report for free, once a year.
Can't I just get them online from one of those credit reports places?
Don't do that. Some of those places do not give you a complete report and they put your name on some list which they sell. Then you want to look over your credit report and dispute some issues. You don't want to clean your score off completely because then you don't have a credit score. The credit score is based on the last activity date as well as the age of the accounts and many other factors.
I had a perfect credit score before all of this crap.
Well, you will also want to make sure that your credit isn't maxed out on any one card and that no more than 30% of the card limit is used. Not using a card is also held against you.
I could use this credit score stuff against the courts in a criminal case, right?
Now you're talking. Yes, you can.
Well, I am not just another pretty face.
Sounds to me like you're on your way to going to court to right the wrong that was done to you. I am proud of you.
Thank you.
You're welcome, dear.